Hello, all the CA Inter students. So, today in this Super 35 lecture, we are going to start with one of the most awaited chapter for all the students. I am getting consistent requests from the students community regarding this particular chapter. I don't know why exactly, but lot of repetitive questions will be there. In exam, same 15-18 questions will be there, 15 to 18 questions. Those only will get repeated consistently in examination, but still students are expecting me to do this. Okay, so that's why we are now going to do with this particular chapter, and the chapter is the interpretation of statutes. So with regard to this particular chapter, I have a good amount of questions with me asked from the past examination questions, RTP, MTP, study material, and likely that most of them are repetitive in nature. Okay, but my duty is to put all the questions that were given in examination, RTP, MTP, whether repeated or not repeated. So, with regard to this particular topic called as interpretation of statutes, there are three segments. Number one, interpretation of statute. Second one, interpretation of deeds. Third one is interpretation of documents. Okay, three things. What are they? Number one, interpretation of deeds, interpretation of other statutes, interpretation of deeds, and third one is interpretation of documents. So now let us understand with regard to this chapter. There are, I compiled somewhere around 61 questions I compiled. Okay, how many? 61. In that 61, at least 30 will be repeated. Repeated means what? They are asking the same question again and again. There are only 18 to 20 topics in that chapter. Okay, nothing more than that they can ask. Na? They can ask only the same questions. So, how good they are asking questions, we are going to understand in the today's session. So, with regard to the lecture, I am going to cover all the concepts inside the interpretation of statutes as covered from the question bank. Okay, let's begin. So, first one, explain how dictionary definitions can be of great help in interpreting or constructing an act when the statute is ambiguous. Ambiguous means unclear. Ambiguous means unclear. So, what is this concept all about? So, listen, with regard to the interpretation of statutes chapter, it's a chapter, it's not a act, it's a chapter. So, whenever you read this, there is no need that as it is we need to write, but at least 70 to 80% try to replicate the text of the material. Remaining 20-25% you can add a general English and write the sentences and answer your question. That does not mean use your own story screenplay direction. No, as it is you need not write. Okay, meaning should be conveyed to the valuer in the examination. With regard to that, let us understand what is the importance of this particular question called as a dictionary definition. Okay, let us first understand what to write in exam. Before writing in examination, I will tell you this question was repeated. See, MTP October 18, previous year examination November, super, yeah. MTP it came very next month exam conducted, in that month this question came. Okay, old and new study material also it is there. First listen carefully. When a question comes to you in examination regarding the dictionary definitions, how to react to that answer? First listen carefully. Whenever you want to know the definition of a particular term, first you need to read the act. First you need to read the act and find out the meaning within that act. How? You can read sections, section number 2, definitions, there you can find it. No sir, I did not find. See the explanations. Section explanation, is there any definition to that? No sir, not there. Then go for the other things within the law itself. Means what? Read the rules, other things. Okay, if nowhere the meaning is ascertained, then when the real meaning could not be ascertained, that means if a word is not defined anywhere in the act itself, then we may refer, not shall, we may refer to the dictionary definitions to know the general meaning of the term, to know the general meaning of the term. Second one, I repeat this statement, listen. Question came on dictionary definition. What we have to write? First, we need to refer the act to find out the meaning of any particular term used within that act. Point one. If the word is not defined within that act itself, then one may refer to the dictionaries to know its general meaning. Okay, general meaning. General meaning in short, commonly how the people will understand that. For that you can read. Clear? But when I say general meaning, okay, when I say general meaning, I will show you an example. I will show you one example. See here. Dictionary. Dictionary meaning they have given. So leave. Okay. See here. I opened a dictionary now. Okay. English dictionary I clicked. Some word I wanted to search. Let us say this way. I will search, say for example, company. What one? Company. Company I have clicked. See, an organization that sells goods or services in order to make money. This is one meaning. Okay, this is one of the meanings that can be given. One of the meanings. Next, the fact of being with a person, company, that company with a person. If you have another accompany with you, we call it now come as a company with me, that company. That is another meaning. Okay, these are all the various definitions. See, company, group of actors, singers, dancers who perform together, like that also you can. Company, large group of soldiers, an organized group of young women who are guides. So like that you can. So say one word is defined in dictionary in a different way. Okay, but one thing is clear, company term is already defined in the Companies Act. Therefore you need not go to the dictionary. I have given one example. What example I wanted to show you? When you start reading the dictionaries, you will not find one answer for one word, you will find multiple meanings for the word. So start from the beginning. First, whenever question comes on dictionary definitions from today till you write exam, what you have to remember? First one has to refer to the act in the question to know about the meaning of a particular term or a word used in the act. If we find that word as not defined in that particular act, then one may read the dictionary to know the general sense or general meaning in which that word is commonly used. Okay, that word is commonly used. But there are several meanings given to a single word na? Then you should take a reasonable care in selecting which word you want. For example A, company term is not defined in the act. Company term is not defined in the Companies Act. Then which, you are reading Companies Act, then which company? Accompanying la company, organization la company, organization. So picking up a right meaning to the word is your headache, reader's headache it will be. Listening. Number 3, this is a point number 2. So what are the two things I said when it comes in exam what to write? Number 1, first we have to refer the act in the question to find out a meaning of any particular term or a word or an expression. First you have to read the act. Next, if you find that the word is not defined within the act, then refer the dictionaries to know about the general meaning of the term. Okay. Next, however, when you are selecting one out of several meaning of a word, you should always pick that word from the context in which you are reading. When you are reading the Companies Act, accompanying with a group of people is not the term you need to select. Company, organization related you need to pick up. That's a third point that you have to write in exam. Everyone clear? Very very important. Next one, than dictionaries, sometimes the terms and words are defined in the case laws, simply to understand judicial decisions. Which decisions? Judicial decisions sometimes laid down the meaning of so many terms in India. Okay, they should be given pari materia. Pari materia means greater importance. Dictionary versus court judgment means court judgment la they defined a word or a definition is defined in dictionary word versus court word, which is given more importance. Court word will be given more importance because they will define the term in the context of that case. Clear? So next one, last one, whenever technical terms are there, whenever what terms are there, technical terms are there, refer to the legal dictionaries or technical dictionaries. Which dictionary? Technical dictionary. Example, for example, there is a law called as a Narcotic Drugs and Psychotropic Substances Act. In that act they will talk about leaves. Ganja leaves, these leaves. What is that leaf called? Leaf called as? What is that leaf called? What is the real meaning? You have to go to the scientific dictionaries, understand the technical word inside that, and then you have to understand in that way. Okay? Because that will not be defined anywhere in any law. What is ganja means, where it will be defined? Nowhere. Technical dictionary la ganja is a general peculiar word people will use, but really what is that leaf, there is some scientific name or not? For the technical term you need to go to the technical scientific dictionaries and look into. Okay, now summarize your answer. If a question comes for 3 marks or 4 marks from this, what you will write? Dictionary definitions. Number 1, whenever a word has to be defined, first we have to refer the act in which that word is coming. Okay, so that means technically to understand, first one need to refer the act to found out any particular word or expression is defined within that act or not. Where you did not find it as defined in that act, then you may refer to the dictionaries to know the general sense in which it is commonly used. Number 3, while selecting a dictionary definition from the words, selecting a right word is of more importance. Number 4, when it comes to comparison, okay, judicial decisions should be given pari materia, means greater importance than that of the dictionary meaning. When there are technical terms, refer to the technical dictionaries. These are all the 6 points you have to write in exam. See, what I said will be there. First, we need to refer to the act in question to find out the particular word. Where we found out that word is not defined in the act, we refer to dictionary. We may, that's what I said, to find out general sense in which it is commonly understood. However, selecting one out of several meanings, I told you, we must always consider the context. Okay, next one. Next one. Okay, leave this main point. Further, judicial decisions laying down the meaning of the words is in pari materia will have greater weight than that are furnished by dictionaries. Technical terms can refer to the technical dictionaries. These are all the points you have to write. Okay, to sum up everything, you have to remember na. So to sum up everything, take a rough page or take a book. Whenever question comes in this interpretation, I will also summarize how to write an exam. Okay. Dictionary meaning. First point, what we have to write? Refer to the act for word or expression. If not, may refer to dictionaries. Selection of one out of various term depends on context. Judicial decisions are greater than dictionary meaning. Technical terms ki technical dictionaries. Next question. This is question number 1. Question number 2. Explain the mischief rule of for interpretation of statute. Also give the 4 matters it considers in construing an act. Okay. Mark it important. This question was tested for multiple times in the exam as well. Name of the concept is the mischief rule. What is this mischief rule? Actually, there is no concept of mischief rule. It is also called as a rule of beneficial construction. Rule of beneficial construction. This is called as a mischief rule. Some people will call it Hedon's rule. Some people will call it beneficial construction. But what law has done is beneficial construction, mischief rule, they're separated in the textbooks. Okay. So that's the only difference. Or else conceptually, if you see, mischief rule and beneficial construction both are same. Both are same. Sir, what is this concept of mischief rule or beneficial construction? Anything. Okay. First, let us understand what is this mischief rule or Hedon's rule or beneficial construction, also called as a purposive construction. Okay. Let us understand. Whenever the language used in the sections or in the act is capable of more than one interpretation, This line, if you don't write, marks will not be given. Mug up in some way or the other way. When the language of the section or the act is capable of giving or capable of having more than one interpretation, then the principle laid down in the Heddens rule or mischief rule will be activated. Second, so when Heddens rule will apply, the application of Heddens rule will come when the language of a particular section is capable of more than one interpretation, the rule laid down in the Heddens case will be applied. Number one. Number two, this rule is also called as a purposive construction or beneficial construction or a mischief rule. Number two, when when a particular language of a section is having capable of giving multiple meanings, court should take that meaning which will suppress the nonsense. The nonsense they call mischief. Okay, wrong meaning is called as mischief. Mischief means children doing mischief things, not that mischief here. Mischief means a wrong meaning. Okay, court should suppress that wrong meaning and apply such meaning which will give a remedy. Remedy means a solution. Okay, so the words used in this particular chapter by the textbooks are all general English. They are not talking about a legal English. They are saying mischief in a legal term means giving a wrong meaning. Remedy in the law meaning means giving a solution, showing some solution to the problem. And evil means not evil deadly evil. Evil means a bad. Evil means a bad. Evil it wanted to suppress, they will use. What do you mean evil it want to suppress? No, they will do all Harry Potter spells. No, that's not the evil here. Evil here represents about the bad it wanted to. The court wanted to kill the bad in the law. Whatever the bad intention is there, which people generally understand, they wanted to suppress that. So anyway, in every question, some important points will be there. Na? In this question also, some important points you have to present in exam. Number one, when the language used in the statute or in the law or in the act or in section, anything you can write, is capable of more than one interpretation, then capable of one interpretation, then the Heddens rule has to be applied. Which rule? Heddens rule has to be applied. What is this Heddens rule saying? They said this Heddens rule, another name is also there. Okay, point number one. When a language of the statute is giving a multiple meanings, when the language of the statute is capable of giving more than one interpretation, one interpretation, then one has to follow the Heddens case. Number two, Heddens case is also called as a purposive construction or mischief rule or rule of beneficial construction in general. Number three, when the words are capable of giving multiple meanings, court should take such a meaning to that terms or phrase, whatever the case may be, to that language, such that it should suppress the mischief. It should suppress the mischief and advance the remedy. Advancing remedy means what? Providing a solution. That's what the point. Everyone understood the point or not? So when the meaning, when there is a cap, when their language is capable of giving more than one meaning, courts will adopt this particular rule. Understood? I will give a fantastic super duper example also for this. Before going into that, let us see the text. Where language, whatever I said is there or not, let's check. Where the language of the statute is capable of more than one interpretation, principle laid down in the Heddens case is followed. Point 1. Next, this is known as purposive construction or mischief rule. Point 2. Next, this rule directs that court should adopt that construction which shall suppress the mischief, advance the remedy. Point 3. Next, when Heddens case should be used, when the words are ambiguous. Ambiguous means unclear and reasonably capable of giving more than one meaning, then that rule has to be used. Number 4. How to advance a remedy? How court will provide a remedy? What court will do? Court will consider 4 questions. Court will consider how many questions? 4 questions. These 4 questions, if they are answered, court will go for purposive construction or mischief rule or Heddens rule. What are the 4 questions? Mug up these literally. Very, 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 very important. Understood? First, what was the law before making of the act? Next, what mischief or defect for which law did not provide? What is the remedy that act has provided? What is the reason for the remedy? These are the 4 questions one should ask while going for whether to apply the mischief rule or not, or how to apply the mischief rule. These are the four questions that should be answered. Means the head-ends rule or purposive construction consider four questions. What was the position or what was the law before making the act? Second, what was the mischief or a defect that the law did not provide for? And what is the remedy act has provided? What is the reason for the remedy? Sir, I did not understand one. What is the law act here? Foundation law we learned na. Law has six components. Act, rule, notification. Not that law. Law means rules that are traditionally followed. Okay, simply in your language, if I have to tell, ethics, or simply law means unwritten act, generally traditionally people are following. I will give you examples also. You are going inside a temple, church, or a masjid. Okay, it is a tradition that we have to leave our footwear, keep your hands clean. It's a sacred place. God is probably, people believing that he is there inside. Be clean. So therefore you call any religion here, religion is irrelevant here, the concept of the worship is important. Okay, so you are going inside, you will wash your hands, wash your legs, keep it clean while you are going inside. That aura must be positive always. This is the culture which we are generally traditionally following over ages. Okay, it's not there in any act. That is law. Law means what ethics people are generally following is like this. However, sometimes when the law, the general tradition what you follow is capable of misinterpreted or interpreted in two three different ways, then act will come and find its place. Act will tell that do this. Are you understanding the point or not? Okay, I will give you one example here. Okay, I will give you one example. There is one section in Companies Act. Probably I will show you directly. Then you can understand. Okay. See here. In this, there is a mischief rule. Okay. This rule of purposive construction is applied in this case. 188 related party transactions. I will first explain the idea. Okay. Then you can remember. Actually, what happened is 1956 Companies Act, there is no section called as related party transaction. There is one section called as section number 297. There is a section called as 297, contracts with directors. Okay, but that section is not so proper. Okay, it was an improper section, not properly providing for the entire nonsense happening in India. 2013 Act when they made, they brought this concept of related party transactions, section number 188. Now what I am going to tell, listen. Whenever company enters into a related party transaction, there are some related parties. Director is a related party, directors relatives are related parties to company. A firm in which director is a partner is a relative to related party to company. A private company in which a director is a director or a member, that company is a related party to our company. Like that, list of 8 related parties are given. List of 8 related parties are given. With those related parties mentioned in section 2 clause 76, if company enters into any contract or arrangement, it becomes a related party transaction. 2007 time, Satyam scam happened. Satyam scam, when it was dig out properly, they came to know that most of the fraud transactions made by Satyam company are with the related parties. Then they found that 1956 Act, okay, 1956 Act, lot of mischief is there, and moreover, it does not provide a proper regulation for related party transactions. What is happening previously and before 2013 Act? What is the scenario? What is the scenario? Means general meeting. Whenever there is a related party transaction, matter goes to general meeting. Shareholders have to approve. Shareholders have to approve. Listen carefully. I am the director. I am the director. My brother is sitting with me. With him, company is entering into contract. He is also a member. I am a member and managing director. I am a member and managing director. My brother is a member only, not a managing director. Okay, member, I am a member and managing director. Being a member, I attended general meeting. He is also a member, he also attended general meeting along with me. Both of us are sitting like so many people are sitting in the company general meeting. Previously, Satyam Kesla, what happened is same. Ramalingaraju, the main managing director of company, is a managing director come shareholder. He is holding 47% in Satyam company. He is sitting. His brother is there, some XYZ. He is also sitting along with him. Company is entering into contract with him. Correct? He is also a member. He is not a director, but he is a member, brother. He is holding another 4-5%. At a 50 to 53%, they are only holding family members. What is happening now? Company entering into related party transaction. Then what they will tell? It require ordinary resolution. Ramalingaraju and his brother being member, they will raise the hand. Once they raise the hand, what will happen? Transaction is approved. That means even if the other shareholders of the company wanted to say no, their no has no voice because ordinary resolution has been passed by these two fellows. That's the problem. Okay. What is the law before that? The law before that is, okay, the law before making the act is, what is the rule before making the act? Rule means general rule, not act rule, notification rule. Normally, what people are following, related party transactions, when they come to the shareholders general meeting, related party being a shareholder also can vote. Okay, that was the law before making new companies act. Second one, what was the mischief or defect for which law did not provide? Previous companies act law, what is not provided? Or that general ethics what you are following, what is not provided? You are not prohibiting related parties from voting, you are allowing them. Okay, so first one, what was the law before making the act? The law is even related parties can go and vote. What is the defect that you did not cover in the old act or in the law generally? Related parties are not prohibited from voting. Okay, what Companies Act 2013 has provided? Companies Act 2013 has provided a remedy. See this. Provided further that no member of a company shall vote on such resolution to approve any contract or arrangement which may be entered into by the company if such member is a related party. This text used in this section. Okay, I will give 1 minute time. Everyone read it. Lot of knowledge you will get here. Now, after the video, I definitely will put the comment. Kaushik da. Okay, let us read. No member of the company shall vote. Listen, no member of the company shall vote on such resolution. Which resolution? The resolution to approve any contract or arrangement which may be entered into by the company. Okay, that means a related party contract or arrangement. If such member is a related party, if such member is a related party. This gave two meanings. What I said, when you should use the Haydn's rule, if the language of this section or a statute is capable of more than one interpretation, then one should use Haydn's rule. Do you know what two meanings that people has got? Do you know what two interpretations this section has given? Question. See, I will give example. I told her, Kaushik, after the end of this example, you will understand why I said that. Okay, lot of efforts are required to take interpretation of statutes chapter. It's not like telling any story. Na? There should be a proof for our interpretation as well. Okay, see the screen. Definitely, once after this, na, so how lawmakers are great. See, there is a company called as X Limited. In this X Limited, A is a director and also a member. B is a member, not a director, only a member. Okay, this is scenario. Now, who is B? B is a relative to A. As per related party definition, director is a related party to company, not only director. A relative of director is also a related party. Therefore, who is a related party here? He is a related party. He is also a related party. A is a related party. B also is a related party because A is a related party because he is a director. B is a related party because he is a relative of the director. Both are related parties. With whom company is entering into contractor arrangement now? X Limited is entering into contractor arrangement with B. With B. Okay, both of them are members. One is a director and member, and the other one is only a director. Okay, this became a related party transaction. General meeting held. In that general meeting, so many people are sitting. One of the chairla director, A sat. One of the chairla, B also sat. Okay. Now the question is, A can vote, B cannot vote. A cannot vote, B can vote. A can vote, B also can vote. A cannot vote, B also cannot vote. Which of the four answers are right is a question. In this one thing is very clear, yeah. Okay, in this one thing is extremely clear. What is that one thing that is clear? The thing that is clear is both of them can vote is a nonsense answer. They cannot vote. But the question, A can vote but B cannot vote, huh? Because A is a direct related party. Okay, A is a direct related party. Through him only B became related. Therefore, A is only prohibited but B is permitted. No, 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 sir. A is not permitted. A is first one. What I said? First one I discussed about this one. Okay. A is a direct related party. Na first A is a director. That's why relative of A became related. Therefore, A is prohibited but B is not prohibited. No, no, sir. A though he is a related party, first related party, but contract is entered into with B, na, therefore B is prohibited. This is right answer. Or no, no, any related party who is a member will be prohibited. Therefore, A, B both will be prohibited. Which of the following is a right interpretation? Everyone has broken their heads. Okay, so listen carefully what I wanted to tell. Now, the language of the section is capable of giving more than one meaning. Capable of giving more than one meaning. See, no member of a company shall vote on such a resolution to approve any contract which may be entered into by the company if such member is a related party. Here, language is very confusing. Do you know why? No member of a company shall vote means if you are a related party member, you cannot vote. But confusion again started. Which may be entered into by the company. This language given two meanings now. Why? Contract is entered by B only, not with A. Here in the example. So some people said B only cannot vote, but A can vote. Some people who said that? Those who read the section saying that entered into by the company with whom contract is entered B. Therefore, B being a member cannot vote, but A can vote. This is one some people interpreted. Some other people said no, 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 no. This should not be given importance. No member of a company who is a related party. Like that you should read. So there is a debate that went for 1 year. Court has given a judgment. Court said that we are applying a mischief rule. We are applying what rule here? Mischief rule. Court said that we are going to apply mischief rule. What is this mischief rule? When the language of a particular statute is capable of giving two meanings, then two or three or like this, three meanings it has given. So then listening, then we have to apply Heden's rule. So whenever the language is unclear or ambiguous, where the court has a doubt as to which one to apply, court should apply such construction which should kill the mischief and successfully put a remedy. In that context, 4 questions has to be answered. What is the law before making this particular section? Directors and members are attending the meeting, they are voting. Okay, what that does not provide, no prohibition was provided in the old act. What act provided? They said this section. In this section, what is the confusion? Now I have to prohibit the A being a director and member, or B with whom contract is entered, both. Answer is both. Directors, MDs will have huge shareholding in a company generally. Mukesh Ambani is there. He is the 41% shareholder, yeah. If you don't prohibit him, for example, I am Mukesh Ambani. I am only Kaushik Mukesh, I know. Example, I may become, na? I may become, chance is there, na? Chance is there. Maybe my Pushpa 2 rule may start. Who knows what will happen? So, anything can happen. Sir, okay, listen. Mukesh Ambani is there. His son is sitting with him. Okay? His son is sitting with him. With Mukesh Ambani, Anant Ambani is sitting. Company is entering into contract with Anant Ambani. Okay? Common sense that you use. You are saying Anant Ambani only cannot vote, Mukesh Ambani can vote. I am holding 41%. I will vote against my son. Na? Definitely I will vote in favor. Therefore, intention of law is what? Interested parties should not vote is the intention. To make that remedy, to bring that solution, what you have to do? Though the word used is which may be entered into by the company, that word should not be given more importance. Are you a member? Yes, sir. Are you a related party? Yes, sir. That's it. You are prohibited from voting. This is how the construction was made in the court of law relating to this section. Recently, 2022 lone this case law happened. Later, MCA came with circular as well on this. Okay. So, what are the 4 questions that you need to write in examination when this question is tested in exam? What was the law before making this act? What mischief it does not provide? What remedy act is providing? What is the reason for remedy? To prohibit them from voting, to protect the interests of the shareholders, not to enter into unnecessary related party transactions and divert the funds of the company to the directors and their relatives. See, in the interpretation of statutes chapter, if we start taking this much time, it will take. But once you understand, lifetime guaranteed, you need not again read. Okay, next. Explain the principles of grammatical interpretation and logical interpretation of the statute. First I will do one thing. Okay, I will first explain you about what is grammatical interpretation, what is logical interpretation in a general plain English. After that, what to write in exam we will see. Okay, So first listen, later you can see the answer and read it. First let us understand generally what does they mean. Okay, first let us understand one thing. First let me explain what is this grammatical interpretation and logical interpretation. In order to ascertain the meaning of any law or a statute, whatever the case may be, we are having 2 options. Listen to my words clearly. Like this only you have to write in exam. Okay. In order to ascertain the meaning of any term in a statute, there are 2 options available. Number 1, grammatical interpretation. Second one is a logical interpretation. First one, grammatical interpretation, logical interpretation. Okay. Both of them should achieve 2 things. Number 1, real meaning of the law, and the intention of the lawmakers, the intention of the legislature should be successful. Okay, I said you 2 points now. 2 points you have to write first. This question called as grammatical interpretation, this particular question was tested for multiple times in examination. Okay, whenever I have not written anything, MTP, RTP, these are all study material. Same questions got repeated one more time in MTPs and RTPs also. Later it will come. Okay, so first listen carefully. What you have to write? Whenever a question comes on grammatical interpretation and logical interpretation, the first point that you have to quote is, in order to ascertain the meaning of a particular word or a term in the law or a statute, Okay, it can be done by two options. Number one, go by grammatical interpretation or by logical interpretation. Number one. Number two, in both the cases you should give a real meaning to the terms. Okay, real meaning to the law, and not just a real meaning, it should be successful in bringing the real intention of the legislature means the makers of the law. So lawmakers real intention should be always brought out. Second point you have written. Third, okay, grammatical interpretation, name lone clear, it will go by literal interpretation of the provision. Grammatical interpretation will be going by, okay, going by exclusively by the verbal expression of law. Go by the verbal expression of law. What do you mean by that? Whatever the words they use, I will read it and I will convey. Example shall I show you? See here. See, let us take the same example 188. What is grammatical interpretation? Except with the consent of the board of directors, given by a resolution at a meeting of the board, and subject to some conditions said in the rules, no company shall enter into any contract or arrangement with a related party. This is the thing. Grammatical interpretation means what? Give a normal English meaning to the verbal expressions used here. Give a real meaning. Except with the consent. Consent means permission of the board of directors. Board of directors means the directors appointed to the board of a company. Except with their consent means what? Without their consent you cannot do. Okay. By a resolution at a meeting of the board, conduct a board meeting and pass a resolution and take the consent of board of directors. And some other conditions kept in the rules as may be prescribed means rules. No company shall enter into any contract. Company should not enter into a contract with the related party. Clarity. This is called as a grammatical interpretation. This grammatical interpretation, another meaning is also there. It's called as a literal construction. Which construction? A literal construction. Literal construction is a concept where we will interpret the law as it is. Okay. We will go by the verbal expressions of law. Okay. Repeat. How to write in exam? They asked you a question. Write about grammatical interpretation versus logical interpretation. What you have to write in exam? Normally, okay, normally the language of a particular statute, to ascertain the meaning of a particular word in the law or a statute, one has two options. Number one, go by a grammatical interpretation or by a logical interpretation. Logical interpretation. In both the cases, you should achieve a real meaning and the intention of the legislature. Point number 2 over. Point 3. Grammatical interpretation will be exclusively going by verbal expression of law. What way? Verbal expression of law. What do you mean by verbal expression of law? Just it will go by the words used in the law. Just it will go by words used in the law. As it is, whatever the law has used, interpret the words in its right sense, complete it. Okay. So, first 2 points let us read. In order to ascertain the meaning of any law or statute, two principles you can use. Grammatical principle, logical interpretation. In both the cases, what you have to do? Give a real meaning of the law and intention of the legislature. 2 points over. For that, they will give you that 1 mark first. This is a question that comes for 4 marks. 1 mark over. Next, what grammatical interpretation do? Grammatical interpretation concerns itself exclusively with the verbal expression of law. Means what? In law, words, verbal expression means words used. Words used, na, I will go by that. I will not go beyond what is there. Except means exception. With the consent. Consent means permission of board of directors means like that. Every word I will give general meaning to that and I will read. I will not go beyond the terms, beyond the meaning of those terms. Okay. I will give general meaning to the terms. Okay. So listen, it does not go beyond the letter of law. Okay, it does not go beyond the letter of law. Beyond letter of law, it will not go. It will not try to understand this word will have how many meanings. When a word is giving two meanings, then go by a right meaning. When word is giving only one meaning, unnecessarily don't do overaction and try for two meanings for that. When two meanings are there, try giving one meaning from the context. Okay. But when a word is giving only one single meaning, for example, consent. For example, what is that? Consent. Consent, the word is used in 188. Consent. Consent means what? How many meanings are there? Anta overaction oddu. Consent means permission. That's all over. It does not go beyond the letter of law. Whereas logical interpretation on the other hand, okay, it will not go by the word of law, it will go by, okay, it seeks more satisfactory evidence of true intention of the legislature. In the other words, emphasis in grammatical interpretation is on what law says, that's it. But an emphasis of logical interpretation is what law means. What it meant to say is a logical interpretation. What it says actually is a grammatical interpretation. Logical interpretation lone reasonable construction, harmonious construction, exceptional construction, beneficial construction, ejus dim generis will come. Okay, grammatical interpretation, okay, literal construction will come. So sum up everything. This question was tested 7-8 times in exam. So please, first point, what you should write: to ascertain the meaning of a law or a statute, one can adopt either grammatical interpretation or logical interpretation. Number one, in both the cases, you should give a real meaning to the law, and okay, intention of the legislature should be given importance. Point 2 over. Grammatical interpretation exclusively based on verbal expression of law. It will not go beyond the letter of law. It will give the meaning to the words used in the law as it is. Okay, number 5. Whereas in case of logical interpretation, okay, it seek more satisfactory evidence for the true intention of the makers of the law. Okay, so in other words, grammatical interpretation focuses on what law says, logical interpretation focuses on what law meant to say. Next one, this one from here to here, exam point you have to write. Okay, okay, in all ordinary cases, means in general cases, the grammatical interpretation is the sole form allowable. Generally you are not allowed to do unnecessary interpretation when the language is plain and clear. Okay, in general cases, in all general cases, or generally, okay, grammatical interpretation is the sole form allowable. Okay, because, sir, what is the logical interpretation? Logical interpretation means I will not give importance to the word, I will give importance to the idea of the makers of the law. Idea of the makers of the law. I will not give importance to the words used in the law. I will give importance to the intention of the makers of law. Though the word is saying that, I will not give importance to that word. I will give importance to the intention of law. So court may sometimes delete the word and read. They may add some words and read. Logical interpretation la words are not important, verbal expressions are not important, intention of lawmaker is important in logical interpretation. Grammatical interpretation, the words are important, give right meaning to the word, complete. 85 to 90% of the act will be run on grammatical interpretation. At 10% doubtfulness will be there in sections, then only logical interpretation will sustain. So in ordinary cases, grammatical interpretation is the sole form allowable. Study material, these are the lines used, you have to write the same. Court cannot delete, court cannot add, court cannot modify the letter of law, generally. However, when the letter of law is logically defective, ambiguous, inconsistent, incomplete, court is under a duty to travel beyond the letter of law and to determine the true intention of the legislature. That's it. If you write all these, you will get that marks. Okay. Though we completed only 3 questions, lot of conceptual discussion we made. Okay, there are only 10 to 12 different questions they asked in exam. 12 were repeated for 4 or 5 times. All repeated questions you will find. First 20 questions if you complete in this question bank, next 35 questions are same. Repeated. Only 20 questions are there. Those only they will repeat. Next, explain the natural and grammatical meaning helps in interpretation of a statute. Okay. I will first explain like the previous one. This is similar to the previous example only, but with a small change. Okay. Let us understand the concept of this natural and grammatical meaning. Okay. See here. Statute, whenever you have to understand, you should understand in their natural, ordinary, and in the popular sense. Natural, ordinary, popular sense. Means what? Read a particular term in its natural sense. Okay. Ordinary meaning. English la what they call this? Do the same meaning to that. Okay. And it should be construed to their plain, literal, and grammatical meaning. Okay. I repeat. Statute are to be first understood in their natural, ordinary, and in the popular sense. Okay. And must be construed means must be understood in their plain, literal, and grammatical meaning. It's sentence first you have to write. Repeat one more time. Statutes are to be understood in their plain, ordinary, or natural, ordinary, and popular sense. Natural, ordinary, and popular sense, and should be construed in a plain, literal, grammatical meaning. One point. If there is any inconsistency, if there is any absurdity, means wrong intention, repugnant, if it is against or inconsistent with the grammatical sense, then one may go for another interpretation. Okay, I repeat one more time. Statute ought to be understood in its natural, ordinary, and popular sense. Means what? Naturally, what is the meaning of the term? Give that word. Ordinarily, what people will tell? Give that word. Popularly, what people will use that word for? Give that one. So there is no unnecessary construction there. Give its plain, literal, general, grammatical meaning. However, sometimes grammatical meaning may lead to absurdity. Okay, absurd means wrong meaning, absurdity, repugnant, or against to the provisions. Okay, in such a case, give it logical meaning. Give it the logical meaning. That means you can then modify or extend or abridge the meaning of that word in order to avoid the inconvenience. Okay, so how to write an exam? Statute should be understood in its natural, ordinary, and popular sense, and construed in a plain, literal, and grammatical meaning. Point number one. Number two, if there is any inconsistency which is leading to, or if it involves any absurdity, repugnancy, inconsistency, grammatical sense, the grammatical meaning must be modified or extended or abridged. That's all. No further thing you should do with it. One example, let us take from the institute material. Once upon a time, they got a problem. What is the problem? Whether beetle leaves, the beetle leaves are subjected to sales tax or not is a question. Okay. Now the question arises. They said any kind of leaf which is sold for human consumption, any leaf which is sold for human consumption will be subjected to sales tax. This is what they said. What kind of leaves they are? In that they also said beetle leaf. In that what they said? Beetle leaf. But in reality, there is no word called as a beetle leaf anywhere in the dictionary at that time. Okay, and moreover, try to understand, grammatically people generally in the outside world they call beetle leaf, but in reality for that scientifically there will be another name. Another name. For example, flowers will be there. Flower generally we call rose, hibiscus, etc., but natural scientific name will be different. So beetle leaf is not there anywhere in any of the technical dictionary. Beetle leaf has another different name. They said beetle leaf is subjected to income tax. So people said real beetle leaf will be there. Now they said this is not a beetle leaf. This has another meaning. In the law, beetle leaf is subject to sales tax. The word beetle leaf is not defined anywhere. Court said that when there is natural ordinary meaning, go with it. If not there, go by popular sense. Generally outside popularly what people will call it beetle leaf, go with it. Even though the word beetle leaf is not defined anywhere in the act or in the science, nowhere in the technical dictionary they define. Generally what people will tell beetle leaf, that's it. Beetle leaf is subjected to sales tax. So listen, whenever contains a word, it should be understood in its natural, ordinary, and popular sense, and should be construed in a plain, literal, and in a grammatical sense. However, if the grammatical interpretation of a particular word is leading to absurdity, repugnancy, inconsistency, then the general meaning should be modified or either extended or abridged, and no further things should be done. Statute are to be first understood in their natural, ordinary, popular sense, and construed in a plain, literal, and grammatical meaning. But when it involves absurdity, inconsistency, or repugnancy. So, 1, 2, 3. These three words you have to remember, yeah. Okay, always whenever we are reading a statute, that statute must be, the words used in the statute must be given their natural, ordinary, and popular sense, and it should be construed in a plain, literal, grammatical sense. If the plain, literal, grammatical sense is leading to absurdity, inconsistency, repugnancy, you can extend, you can modify, you can abridge the provisions of the law and read accordingly. Case like example also you have to give. Okay. Next one. What is the next one here? Understanding the rule of harmonious construction. Understand the rule of harmonious construction. I will first tell what is harmonious construction. Later we go into the reading of the text and going with an example as well. Okay. First let us understand what is a harmonious construction. Listen. When there are more than two provisions talking about a same issue, okay, I will give you in a general meaning. I will explain first. There must be minimum two provisions. I said that may be two subsections, that may be one section and another section, anything can happen. There must be minimum two sections or two provisions. Both the provisions must be discussing about the same subject matter. Okay, there must exist a conflict. Which one to apply, this one or this one? Conflict should arise. First try to avoid the conflict and apply both the sections. I repeat one more time. Whenever there are two provisions talking about the same subject matter, whenever two provisions are discussing about the same, there must be minimum two provisions should discuss about same subject matter. Now there exists a conflict. What conflict? In my context I should apply this or this. In that you have to understand one thing. Lawmaker written two sections means two sections are having importance. Yeah, how can you tell this is important than this? If this is really not important, he wouldn't have written. So both the provisions must be given importance. So rule, there must be minimum two provisions must discuss about same subject matter. There exists a conflict as to the applicability. In such case, apply both the sections. If in case we can't apply both the sections, then specific section will prevail over general section. Shall prevail over general section. So let's understand. When there is a doubt about the meaning of the words used in the statutes, these are understood in the sense in which they harmonize with the subject of the enactment and the object which legislate had in the view. Where there in an enactment two or more provisions, there must be two or more provisions which cannot be reconciled with each other, means which can't be read together. They should be so interpreted as to give effect to all of them. That's what I said. Whenever there is a conflict which can't be reconciled, then apply both the sections. That is known as rule of harmonious. But if reconciliation is not possible, it must always be borne in mind that statute is passed as a whole and not in sections, and it may be well assumed that it to be animated by one general purpose and intent. Okay. Okay, next. The court's duty is to give effect to all the parts of a statute if possible, but this general principle is meant to guide the courts in furthering the intent of the legislature and not overriding it. Okay, so the point is, in examination, that much of technical detail you need not write. Mainly this paragraph you need to write. Okay, first, when there is a doubt about meaning of the words of a statute, okay, you have so many constructions: rule of reasonable construction, harmonious construction, beneficial construction, exceptional construction, ejusdem generis. In that, whenever the words of a statute are, okay, when you have a doubt about it, one of the rule that you can use is harmonious construction. Okay, the object of the legislature had in view. Where there are in an enactment two or more provisions, so two or more provisions are there, both the provisions are discussing about same subject matter, but there is a conflict, they cannot be reconciled with each other, then in that case you should give effect to all of them. So whenever there is a conflict existing between, resolve the conflict and apply both the provisions. Okay, this is known as rule of harmonious construction. Okay, why we have to apply both? One should keep in mind that statute was passed as a whole, means everything is important, not in sections. Okay, it is, statute is written as a whole, every section has its own importance in it. You cannot tell this is more important than this. Okay, so the court's duty is to give effect to all the parts of the statute if possible. Okay, if possible. Next, this is important for exam. The rule of harmonious construction is applicable only when there is a real and not merely apparent conflict between the provisions. Okay, what doubt you got is not important. Really, there should be a conflict. Really, there should be a conflict between the provisions. And one of them has not been the subject to the other. When, after having construed their construct in the word is capable of only one single meaning, the rule of harmonious construction disappear and is replaced by the rule of literal construction. Means both the sections are two different discussions they are making. There is no conflict at all. If there is no conflict, go by literal construction or else go by harmonious construction. Okay, to sum up everything, let's try to understand what is the rule of a harmonious construction. The rule of harmonious construction, to apply, there must be minimum two provisions in the law. Two provisions are discussing about a same subject matter, therefore there exists a conflict and we can't reconcile each other. In such a case, apply both the sections, because law or a statute is made as a whole and not in sections. Court should give importance to all the terms of law and apply. However, if there is a problem in applying both of them, then go by harmonious construction. Next, if if there is only one single meaning that you can give, there is no conflict at all. In such case, it will be replaced by the rule of literal construction. Okay, I will give one example. They didn't give example, na? I will give you one example. Nearby example only I will give. See, powers of the board. Powers of the board. The board of directors of a company shall be entitled to exercise the powers. If you see subsection 3, the board of directors of a company shall exercise the following powers on behalf of the company, okay, by means of passing resolutions at a meeting of the board. What is the essence of this sentence? These powers board of directors have to exercise by passing a resolution at a board meeting. Okay, not just by emails etc. Come to the board meeting, sit, take a decision across the table and resolve. Okay, in this you remember this point. This is 179 subsection 3 clause D. Borrow monies. Borrow money. Money borrowing should be made by taking a decision by the board of directors at a board meeting. Is the intention. Next, which section? 179 3D. There is another section called as a 180. There is another section called as a 180. Okay, see here. 180 section, what they said, the board of directors of a company shall exercise the following powers only with the consent by special resolution. Means what? These powers A, B, C, D. These powers, okay, following powers means A to D of section number 180. 180 subsection 1 clause A to clause D. These powers can be exercised by whom? Board of directors. By passing which resolution? Special resolution of the members. Okay. Previous one, board of directors at a board meeting. Okay, here they said these powers are to be exercised by board of directors, say, but with the prior approval of the shareholders. Prior approval of the shareholders by passing special resolution. In that, one of the power, borrow money. Borrow money. Okay, na? What money? Where the money to be borrowed, to be means proposed borrowing. Together with means add. Money already borrowed means existing borrowing. Will exceed means greater than aggregate of paid up share capital, free reserves and securities premium. Means borrow money is of two types, within the limit, beyond the limit. What is the limit? Paid up share capital plus free reserves plus securities premium on liability side, total them. If your borrowings, which borrowing? Proposed borrowings are existing are total. Okay, that's why the to borrow money, where the money to be borrowed, okay, proposed, together with add money already borrowed, proposed borrowing existing borrowing. If both together is not exceeding this amount, special resolution not required. If it exceed, special resolution is required. Now listen, special borrowing money require board approval, special resolution approval. Question arises. There are two provisions. Two provisions are discussing about the same subject matter, borrow money. Okay, there exists a conflict which they cannot reconcile. What is the reconciliation that is not possible? 179 section is more important than 180. Then even if the beyond the ceiling limit also board approval only required. No. 180 is very important. Irrespective of ceiling limit, every borrowing will require shareholders approval. Are you understanding or not? So the question is how to interpret. Apply both of them. Means what? That section, 179 section, they just said borrow money. How much? Limit is not mentioned. Means whether 1 rupee borrowing, 10 rupee borrowing, 10,000 crores borrowing, any kind of borrowing first requires board approval. First requires board approval. If it also go beyond the ceiling limit provided, being the paid up share capital freeze or securities premium, along with board approval, you should also apply shareholders approval 180. Like that, we have to harmonize both the sections. Don't tell 179 is more important than 180. Okay, if that be the case, lawmaker don't write 179 or he will not write 180. When they write statute as a whole, you should read statute as a whole. Okay, so this is the harmonious construction. To some extent, you should put some effort in remembering it. Okay, next, important ones I will first take up, repeated ones and important ones. See, again, grammatical interpretation, all these things will continue. Okay, what I will do is, once I will cut this video here, next particular video, continuation to this immediately I will do. In that, I will do another 10 questions in this. With that, 15 questions will get completed. Okay, the 15 will get repeated for 4 or 5 times in the total textbook. Okay, so thank you. Next video, we will come with the remaining things.